Pascal. You are now rocking with that dude Pascal. We be going wild, Haitian in the building, so we're richer now. Got the haters catching feelings. Get your hands up to the ceiling and keep them held high, cause St. Louis isn't ready. Forget about it, goodbye. Hold on, we just saying hi. Five somebody, rise up. Weekdays, catch us live, somebody. Let's go.
Good afternoon, everybody. Good evening. Good morning. Welcome to the Pascal Show. We're here for the Bryan Kohberger hearing. This is going to be a very interesting one, I'm going to say. But I'm happy to be here with you guys. Happy Friday to every single last one of y'all. Okay? Happy Friday to every single last one of y'all. We're still waiting. We're still idly, we're waiting at bated breath for something to happen on this page. We have yet to see anything as of yet. Because I am looking at it right now as we speak. Actually, I'm going to share it with you guys right now too. Hold on one second. Let me grab this. But as you know, I'm keeping an eye on this, and of course, WFLA is live as well. You know, talking, kind of getting everybody prepped and ready for this. And as you can see, I'll show it to you right here. WFLA. Shout out to JB. But we're kind of waiting right now as we keep continuing to refresh. Still not a thing. Okay. Still nothing so far. And they're supposed to be starting they were supposed to start allegedly a minute ago. So we're going to wait. We're going to see what goes on. But they're supposed to be going live here for this hearing. Remember, Kohberger is trying to dismiss these indictments. It's crazy. It's crazy. It's not going to happen, guys. I'm going to keep it a buck with y'all. It is not going to happen. In my personal opinion, there's no way that they're going to be like, all right, let's just throw everything out the window. Nah, but they're going to be, they're having a hearing nonetheless. So this is going to be interesting. And of course, does this mean that we're going to have a trial in the summer or no? That's another question that we have here as well. Hopefully we get those things answered today at some point during this hearing. And I'm also wondering if this hearing is going to be long or if this is going to be a short one. We're also going to find out, obviously, as we watch and watch as a family. So do me a favor, guys, okay? Hit that like button down below. Crush it. Do that solid for me. Don't forget to hit that reaction button if you're watching on Facebook as well. That'd be greatly appreciated. All right. If you haven't done it yet, please go check out that subscribe button just by simply crushing that subscribe button. Subscribe to my channel. That'd be great. If you're watching on YouTube, if you're watching on Facebook, please be sure to hit that follow button on my Facebook page, please and thank you. All right. Go check out my merch page, pascalmerch.com. Or you could just support the channel by simply hitting that join button down below. If you're watching on YouTube, become a part of the family. All right. Or you can join my Patreon. It's in the ticker down below. Patreon.com/The Pascal Show. All right. We got to get into this. As we are waiting, we're still waiting. Nothing has been set. I'm going to keep refreshing this doggone thing. And he hasn't put up anything. It's wild that Judge John Judge is going to be live streaming. And I'm wondering if he's going to monetize this. Just to be completely honest, I'm wondering, is he going to monetize this? Is he going to make money off of this as well? But he's live streaming this on his own channel. Okay? On his own channel. That's very interesting. But as we continue to refresh over and over again, still nothing. But we still got JB. He got some things. He's talking about, covering some things. And obviously he's watching this like crazy, waiting for this thing to start popping off. Okay. But I told you guys I would watch this. I would share this with you guys. We would talk about this. And whenever this hearing actually goes down, we will watch it as a family. and see what the end results will be. Hopefully, I will have some friends, circling in and out, coming in and out of our live to put in their expertise, their 2 cents into everything as well. We will be having some friends coming in, hopefully, as long as everything goes according to the plan. You will be seeing some faces, familiar faces, onto the show. But the other thing, though, too, is this is just weird. The fact that, even WFLA is patiently waiting for this, patiently waiting for something to pop off. I find that to be a little bit weird. Given the fact that Judge, and I'm going to refresh over and over and over again, but even Judge has not put it up. Maybe he's having his first streaming problems like we all have had in the past, right? Maybe he's not very, as somebody, you just took the words right out my mouth, Lulu. Maybe he's not tech savvy and he's still trying to figure out how to log into this ish. But for a fact, a lot of people give a damn about this case, and a lot of people give a damn about this hearing. Every little nuance revolving around this particular case, everyone is glued to their phones, TV, wherever they're watching this. Okay? Everyone is very focused. But as I keep continuing to refresh, nothing. So we will see. I hate that we have to wait like this. That there's other, there's like other outlets, etc. Like when we talk about these, when we see other places covering these things, this doesn't happen like this. Or at least there's a heads up, like, hey, there's going to be a little bit of a hiccup, or the hearing is delayed another half hour, or it's delayed another hour, blah blah blah. They at least let people know what's popping and what to expect. But with this one, not so much. We are just sitting here waiting at bated breath for him to turn the mother-loving thing on. And he keeps growing subscribers. It's crazy. He was just at 16,000 subscribers. He just went up 1,000 subscribers. Like when I went live, he just went up 1,000 subscribers. So now he getting subscribers too now. It's weird. Okay. But, I'm going to wait patiently. But I will say this, though, too, guys. Okay. If you haven't done so, I did upload because I figured something like this was going to happen. Okay. I figured something like this was going to happen. So I did upload a video. There's some new updates or an article that came out where, that is covering some of the family members, some of the parents, or one of the parents of the Kansas City Chiefs fans that were found in the backyard. They spoke out. And so I covered a little bit of that in a pop-up video. So please go check that out while we wait, because it's not happening right now. Clearly not happening right now. So we kind of have to just let it rock and roll, unfortunately, until they actually get this mother lover rolling. But in the meantime, I highly, highly recommend you guys going and checking out that new video I just dropped. Okay. In the meantime. Okay. Until they get something, until they start figuring some ish out. But let me, hold on. Whoops. Let me make sure. Let me make sure we got sound on here. That's important. That is uber important. We can hear JB do his, say his
what we're talking about anymore. Sometimes legal cases can get quite complex and so granular with some of the motions that are filed, and then secondary motions, and then appeals. Sometimes it can make your head spin, but that's why we have brilliant attorneys that are able to help us understand what's going on. The time is now 4:08 Eastern, 1:08 Pacific. No live stream yet from Judge John Judge. Now, you heard Emily say, this is very, very interesting. Emily said that this was there was an attempt earlier this week, I think she said earlier this week, to go live, and it worked. So it was like a test, if you will. Like, hey, does this work?
Technical issues? That's hilarious.
As someone who does streaming for a living, I can assure you that there's 1,000+ ways it can go wrong.
Completely,
your RTMP signal, from your camera feed, not having any audio, to
he ain't wrong with that, though. He ain't wrong with that.
This firewalls coming into play. There's so many different things that can, or it's just as simple as
bye-bye.
Okay, we are on the record. This is State of Idaho.
We are live.
Bryan Kohberger. Case number CR.
Oh, come on. Don't be an ass. Don't be an ass now. Don't you dare be an ass. Don't you dare be an ass now.
Mr. Kohberger, Ms. Mathis is remote.
Come on, you.
Mr. Kohberger obviously is in his courtroom. The state is represented by Mr. Thompson, Ms. Jennings, who is here remote also.
Don't be an ass, man.
Remotely. Mr. Nye and Ms. Bates.
Is that coming from their side? Hold on.
That's what that was all about. I'm assuming that you have all seen the amended order governing courthouse and courtroom conduct. We made some changes.
I'm just fixing something, guys.
And you probably also know that we are streaming now. And that is on a YouTube channel.
He making monies.
If you don't know that, you can.
Come on. Is he breaking the internet? Is that what's happening right now? Is he breaking the doggone internet?
And go to the court, the Supreme Court. I guess website.
This thing is being a pain in the balls right now, guys. One second.
And you can get that that channel if you don't have that already. So you don't want to be on a camera. You probably should leave. But generally, we can't see very well.
Let's try that.
Farther back in the courtroom. So just so you're aware of that. So today we are addressing reconsideration of the.
Come on, man. Work with me.
Order denying motion to dismiss the indictment, and that order is.
I think it just needs to roll through this.
Focus on the.
I don't know if it's the internet over there or the internet over here, because this thing is being a huge pain.
To the Idaho Supreme Court. I think the court has.
Yeah, let me see. Let me see if they're. Oh, shoot.
Noted that it's certainly an interesting
Comments
issue.
have been turned off as well.
Idaho Supreme Court does have a rule that
Hold on, I'm trying something else
essentially
here.
lays out that this is to be done in very rare circumstances, important issues.
It's working on law and crime, huh? Let me try law and crime. Let me try law and crime
Where people may disagree and that may orderly
because this thing
may make it more orderly in a particular case. Our argument is that for this case,
let me just
orderly may make it more orderly in a particular case. Our argument is that for this case to exist, the indictment needs to be valid. If there's something wrong with the indictment, that's something that certainly should be addressed. We're also concerned about the fact that there is case law that says that if this case goes to trial, issues with the indictment may become essentially mooted by that and would never be answered. And there's relatively little in the way of case law in Idaho in the last 20, 30, 40 years. And so without permission to appeal, we may never get an answer on this. And certainly that's very important to Mr. Kohberger, because whether or not there's a valid indictment in this case is going to decide whether or not he sits here and whether or not a trial should occur, et cetera. One of the major issues is whether or not that's going to have an issue with the timeliness of this case. And my understanding is that's going to be the next argument that comes after this one. And so we believe if a trial is set out as far as we think it ought to be, that an appeal at this point won't disturb where we think a trial should occur in any case. And in any matter, this isn't our attempt to achieve some delay. This is our attempt to make sure that our client is getting due process at every step in this case, and that nothing is being left, no stone left unturned. Thank you, Judge.
Thank you, Mr. Langston. Mr. Nye?
Thank you, Your Honor. I want to start with the rule that was just referenced. It's Idaho Appellate Rule 12, and it governs interlocutory appeals. And the criteria in that rule set out two factors the court is supposed to consider. The first is whether or not there are substantial grounds for difference of opinion. And on this particular issue, as the court stated in its order, the standard of proof for grand juries in Idaho has been consistently probable cause for at least 3 decades. That doesn't sound like substantial grounds for a difference of opinion. And in fact, the defense conceded in their opening brief on this issue that, quote, the whole of modern jurisprudence on this issue is against this novel theory that they've raised. So they haven't met that first factor. The second one asks whether an immediate appeal may materially advance the orderly resolution of the litigation. And I have not yet seen in their briefing or heard in their argument any path forward for them in which winning this appeal materially advances this litigation. I think if we're all being honest with ourselves, a trial in this case is going to happen. And the question is when. And if we send this case up on appeal, even if the defendant wins, the law clearly allows for us to bring the case back. Even if the Idaho Supreme Court goes out on a limb and says, you're right, the standard of proof in a grand jury should be beyond a reasonable doubt, we could use a normal complaint and probable cause hearing in front of
Come on, man.
a judge. So it would be the same standard yet again, and we would go in a whole circle, basically resetting the case to be where we're at today. We need to get to a trial in this case. And that brings me to my final point. I'll also try and keep this short. There are secondary factors that the Idaho Supreme Court has looked to in addition to that rule, even when those first 2 factors are met, to decide, is this actually the case that we want to take an interlocutory appeal? And my read of those secondary factors is it's really asking, like, what is the effect of this appeal on the litigation and on the parties and those involved? And I would just like to point out to the courts, under the rules, this is Idaho Appellate Rule 13F, and it's talking about the stay upon permissive appeal. And it says in F sub 2 that the granting of a motion for permission to appeal under Rule 12 by the Supreme Court automatically stays the entire action or proceeding until the appeal is terminated. So at that point, there's no more discretion. It automatically this case. Hits the pause button. But more than that, Your Honor, it continues and says, and during that time, the district court or administrative agency shall have no power or authority over the action or proceeding. We're not just talking about a stay in the proceedings. We are talking about this court.
Talking about this court, come on. My Lord. Of course, when it matters.
Sentence. You can sentence the defendant. You can change bail, things like.
Man,
To lose sight of the fact of the seriousness of this case. We are talking.
oh my gosh.
Talking about a quadruple homicide under Idaho's law. Not only are those who were killed victims, but every single one of their immediate family members is a victim. And in this state, in Idaho, our victims have a constitutional right to a timely resolution of the litigation. We are already quite a ways out.
Yeah, I don't understand what's up with the hiccups.
And the idea that we would hit the pause button and take power away from this court because there is a interesting issue for the Idaho Supreme Court to address is not something that this court or any court should tolerate. It's time for a trial, Your Honor. Thank you.
Damn right. Let's go. Get him to trial.
Judge, once again, we believe this to be an important issue and one that is worth getting a glance, at least from a higher court, rather than being tucked away and forgotten in the maelstrom that is to come. As the state undoubtedly knows, trial won't put an end to this case. This case will go on for 28 years if they do actually achieve a conviction. So the idea that somehow we're running towards something and that's going to do anybody any good from their standpoint is, I think, false. What we're trying to do is make sure that the things that occur in this case are done correctly. And if you want to talk about how long things are going to take, get some stuff wrong, and then see how long it all takes. We're asking that the court would give us permission to go and see if the Idaho Supreme Court would be willing to weigh in on this particular subject. Whether or not the case makes its way to trial at some point is, in our mind, just part of what the court has to look at, particularly in a case where the state's decided that it wants to try to kill someone. Thank you.
Wow. He said that. What? No?
Well, first of all, this is a reconsideration.
Come on, Judge.
Order relating to dismissing the indictment, whether or not the standard for proof on a grand jury is probable cause or beyond reasonable doubt. I don't think we've done anything wrong about that. That decision was put out quite a while ago. It's rooted in well-settled law. And I think it was correct. Supreme Court, I guess, could turn that around, but that is doubtful in my opinion. We went through Idaho Constitution, statutes, case law, criminal laws, and really common sense. So I feel quite confident that that was a correct decision. So that established that it is well established that the standard of proof for indictment in the grand jury is probable cause, not beyond a reasonable doubt, which is the standard for trial. So putting that aside, now we get to this permission to appeal under Rule 12. So, excuse me, let me just get this in front of me.
Come on.
So the criteria for permission to appeal, this is in Rule 12 of the Idaho Appellate Rules. First of all, it's very, very rare in case law for such an appeal going to the Supreme Court. It does happen, but it is rare. And the court has established this criteria. And I'll just read this part of this. The issue needs to involve a controlling question of law as to which there is substantial grounds for difference of opinion. Again, in my opinion, and based in all the law in Idaho that I've
found,
is that there's not a
come on, figure your ish out. Let's go. There's not a what?
Difference of opinion about what the standard for the grand jury is. So the defense is making that argument. I respect that. I don't agree with that, but that's where this is. I don't see a difference of opinion throughout the state about what the standard is for grand jury determining an indictment. But this also has a second component. And this is something that Mr. Nye really focused on, is which an immediate appeal from the order may materially advance the orderly resolution of the litigation. And I'm very concerned about delay. And I think that if we send this to the Supreme Court, that it's going to add delay. Mr. Logston is correct. I mean, this is a complicated case. It could take a long time, longer than any of us want. But I think that would add additional delay. As I said, I'm already concerned about that. We're over a year. Could be another year. I'll just let you all know that.
Oh.
Now,
okay.
Even if the Supreme Court takes up this appeal, or I deny it, I'm going to deny the permissive nature of this. If I deny it, the Supreme Court can still pick up the appeal. That's up to them. But they do look at what the district judge's opinion may have some bearing on that. I hope so. But they could still overturn the order. Including the impact of the immediate appeal upon the parties, effective.
I appreciate y'all still rocking with me. I apologize for this
the
this
delay of
feed.
proceedings in the district court pending the appeal, the likelihood or possibility of second appeal after judgment is finally entered by the district court, and the case workload of the appellate courts. But it finishes with an appeal must be exceptional.
You know, I am wondering. I am wondering that too. You know, I mean, well, I think the reason why they're trying to delay
Seeking of that appeal.
is so that they can
Because the
dig.
Supreme Court doesn't broaden the appeals, which may be taken as a matter of right under Rule 11. So, in my opinion, I do not find that the criteria is satisfied for a permissive appeal.
They're going to delay. They're going to delay. They're going to add delay. That's this crazy. The reason why they're doing this, right? The reason why they're trying to get, what the heck? The reason why they're trying to get, hold on, I'm going to try to get this thing back up and online. Okay, we're back. Well, they want
Thompson?
more. They want delay. Defense wants
Right.
delay. That gives them more time. Okay,
So
that definitely gives them more time.
Mr. Thompson, about the state's position on scheduling.
Yes, sir. I'd be happy to. And to start, Mr. Lodson said something that I think needs to be
He says no.
addressed. He makes the allegation the state is trying to kill someone here, and frankly, I find that offensive.
No
What
doubt.
the state is trying to do is to enforce the law that our legislature has put in place. It says, in cases such as this, with facts like this, a jury is entitled to decide not only guilt, but potential fulfillment. We are simply trying to fulfill our responsibilities under the law. To characterize it as the state is trying to kill someone is just simply appealing to raw emotion, and it has no place in this courtroom. We would ask that that not be allowed any further. Now, as to the trial, Ms. Nyer already noted that we have a variety of competing interests here. We have certainly the defendant's right to a speedy trial, which he has waived at this point. There are also interests of the state itself, and I think even more importantly, the victims and the families of the victims in this case to a timely disposition of this case. Granted, this is a complicated case. It is a very serious case, and a lot of effort needs to rightly be put into it to make sure that the case is handled correctly. At the same time, we need to also balance the need to move forward in a constructive, productive fashion. When the state filed our motion asking for a scheduling order and trial date, which was a little bit over a month ago, we proposed the summer of this year. And at that time, at this time right now, we believe that we could be prepared for trial summer of this year. We realize defense has factors and considerations they want you, Your Honor, to take into account, and certainly we want to afford them that opportunity. I will say, though, that, and that we touched on this in our motion, in our request for the scheduling order, that given the nature of this case, if we are going to try this case effectively with minimal unnecessary harm or disruption to our community, it should be done during the summertime. And I say that because right across the street there is Moscow High School that shares parking all around the courthouse with everybody else who's going to have an interest in this case and being here. And we've already encountered the conflict between those interests. We can't sustain that for weeks and weeks on end. That's just not fair to the students. It's not fair to the school district. It's not fair to the media. It's not fair to anybody.
You ain't wrong.
The other factor is, as Your Honor knows, we have two universities, part of our community. And during the academic year, we have graduations. We have numerous sporting events and other university-related events that essentially consume every available hotel or motel room within miles. This case is going to involve bringing in people from out of state, numerous witnesses from out of state who will have to be put up in lodge. And we would submit that that's going to be unnecessarily complicated.
He's not wrong with what he's saying
Trial
here.
occurs while the universities are in session.
He is not wrong.
So those are the considerations that we have, Your Honor. As I said, we filed this last month at that time, and as we stand here today, we believe that we could be ready for trial this summer. Thank you, sir.
He's got good points.
Taylor?
Thank you.
Oh boy.
Your Honor, I received Mr. Thompson's motion for a scheduling order, and I had the opportunity to meet with him and talk with him and Ms. Jennings about that. So it is no surprise to the prosecution that we do not believe a summer of 2024 trial is realistic in any way. Understanding the state's concerns, if a trial were to happen in Latah County, we would suggest looking at summer of 2025. However,
Wow.
counsel and the court's aware that our intention is to file a motion for change of venue. That hasn't been filed yet because we're not ready to have that heard yet. There's work that has to be done to present to the court and counsel in support of that.
Damn.
So that's just for the court's information.
They've had more than enough time.
Your Honor, that in the state's scheduling order, it asks the court for various things. And a lot of those we don't have disagreement with. We think they're appropriate. And in fact, they were things that were covered by the court in the court's original scheduling order. As the court and counsel recalls, last fall, we had not made the choice to waive speedy trial. And so the court did a scheduling order at that time. It wasn't but a few days later that we'd had enough time to discuss that. And Mr. Kohberger decided to waive his speedy trial, and the court vacated that order. So I'm familiar with what the court likes to put out there as far as a scheduling order, and I don't think there's a problem with that. I would want to inform the court that I do not believe this is a 6-week trial. I believe this is more like a 12 to 15-week trial. This is, as everybody said today, a very complicated case. And I want to talk a little bit about what drives both our request no sooner than summer of 2025. And I say that with fear, Your Honor. There are a lot of things that we have to still do. I want the court and counsel to know that we haven't sat around waiting for a scheduling conference to begin doing those things. We have been on this case and active and seeking discovery and reviewing discovery, meeting with experts and working the case since the day we were assigned this case. So with that said, there's still plenty to do. And I want to talk a little bit specifically about that.
Have mercy.
In a case where there is the potential for a death penalty, we're looking at 2 tracks of trial. We're looking at the innocence phase, where there's tons of witnesses and a lot of things that happen. And if there is a guilty verdict, we immediately go to a sentencing phase. That's up to the jury what happens there, but both parties have to be ready to proceed forward. So we don't get the luxury of focusing on our case, the state's investigation, our own investigation solely. We focus on that. We are working on that, but we are required to begin our mitigation case. That's what it's called.
As it's doing a little hiccup here, you cannot tell me. I mean, I'll be surprised if Judge actually says yes, 2025, summer of 2025. But for the defense to sit here and say we need more time, they've had a whole year already.
The penalty case. We are to put on mitigation. We are guided by the ABA standards, American Bar Association standards, in capital cases. That's what this is. A death penalty case is a capital case. And we're guided by those standards. And they tell us that as attorneys, we must investigate every aspect of the case in the innocence phase. We must meet with our client regularly, which we do. We must engage in experts and understand the issues that are coming, which we are. The American Bar Association guidelines in capital cases say we must hire a mitigator, and there must be a mitigation investigation. We hired a mitigator, probably one of the very first people we contacted. And so that has been ongoing for 13 months almost as well. We have not been sitting back and waiting. Your Honor, in this case, the complexities are that there are special areas of focus. And when we get to trial, counsel for the state will put on experts to educate the jury on specific areas of focus, as will we. And it takes a while to get all of that done. In addition to that, court knows, everything is recorded. There's digital footprints all over the place. And so we have a lot of records that we have to go through.
Come on, you
I
said
know
that
that
last
the
time.
court has heard about 51 terabytes of information that we've received. And I want to tell you what that means. Miss Massa found a statistic for me, and I want to tell you how much 51 terabytes of data is. And she found that. She was looking at Dropbox.com, and 51 terabytes of our discovery, to put it in perspective, 1 terabyte can hold 250,000 pictures. 1 terabyte, and we have 51 of those. Or 500 hours of high definition video, and we just have one of those. So 500 hours times 51, or 6.5 million document pages. And that's equal to 1,300 filing cabinets. And we have 51 terabytes, not just one. So that's a lot. There's specialized knowledge.
Okay.
There's a lot to go through in this case.
You got a team.
We
Make 'em
also
do.
have another player in the case, and that's the presence of the media. This is a case that has drawn a ton of attention from the media, and it continues to do so. And I don't think that's stopping anytime soon. The impact of that is that we have found that when we want to talk to witnesses, sometimes they don't want anything to do with us. Sometimes they're people that have already talked to the media too much, and so we shouldn't talk to them or bring them into the case. So that's just a complication. We're working through it. We're working around it. But that's something that the court has to be aware of. I want to let the court know that there are over 400 potential witnesses.
51 terabytes, they had this for a while now. So they need to start drinking a whole lot of coffee and start getting through that ish. He's got a whole team working for him. They need to do that. I'm sorry. You can't lean on
in the
51
innocence phase alone.
terabytes. You can't be leaning on 51 terabytes forever.
And my team
No.
have talked to less than 10%, well, less than 10% of those witnesses. In the mitigation phase, our mitigation expert has been actively working the case. We've all been working alongside our mitigation expert. There are still well over 100 people left to try to contact and try to interview. And let me back up and explain what we do with mitigation. We are to learn Bryan's life story. We are to go all the way back to before he was born and learn his life story. We have to be prepared to talk about that in different ways.
Okay. You got to be, you've been doing this for months now, for like, you've had this whole trial in this case in your lap for a long time. It's absolute BS for you to sit here and say.
But it's not just a life story. We're required to go 3 generations back on each side, mom and dad. The court can imagine that there are a lot of documents that must be collected and examined and reviewed so that we are aware of things that we would need to present to our jury if we ever got to that phase. We have had a lot of trouble collecting documents. Sometimes it takes a court order to get documents. Sometimes documents are missing. Sometimes they're very old and you have to piece things together. We're working through it, but I want the court to know it takes some time for that as well. There are records yet to be obtained that we need in both sides. There are still experts yet to be hired that we need to find an expert that has the right expertise and will work on the case with us.
For real?
We do have several, we're working with them, but there are still more that need to be found.
That's part of your job.
And then let's come back to the discovery.
Oh, hamburger.
I want to talk about some of the difficulties with discovery, and I want everybody to know that I am not disparaging the state when I say this. I'm describing a complication, a challenge, probably one that the state shares. In this case, we began asking for supplemental discovery in February of 2023. We had some initial discovery, and then we started looking at it and asking for other discovery. We are up to our 11th request for discovery, and there's, I think, 250 items total with subparts to that. The state will respond to us. They're not ignoring us. I'm not saying that at all. There's just a lot out there. But this is complicated because the discovery that we receive, the materials, there's videos, there's interviews, there's police reports, there's photographs, 13,000 photographs that come in. and they are not indexed. So you get a discovery file and there's tons of sub files. And I believe this is the way the state's getting it too. And I believe this is complicated because we have multiple law enforcement entities that have been working on the case. And I believe they filter discovery through one of the entities and then it gets to the prosecutor. And I think they're hurrying as fast as they can to get the discovery to us. So I think they're giving it to us as they get it. But there's no indexing in it. So you must open each of those files and see what you have. And you might have police reports in sequence.
I feel like,
and then you might not. And you might have photographs, but you don't know which officer took them. You can tell where they are, but you don't know which officer, and you don't know what day because the officers were in that residence multiple times. So that's complicated to try to match all of those things up. There are things that we've asked for that have taken, it's just taken a long time. The court knows we've had motions to compel and we've had some pretty lively debates about what certain things that we should have and certain things that they don't want us to have for other reasons. Those things take time as well. We don't have complete discovery. I don't think the state has complete discovery, but we definitely don't have complete discovery. I'll give you a couple of examples. There is a video that's a really important video, and we early on received some of it. And we are still waiting for the complete of it. The court would know from our 11th discovery request that there's still outstanding portions of that video that we need to have. And I think the state's working through it, trying to match up video and sound together for the completion, the full several days worth of video, but there's not even an estimated day when we'll get that. And that is critical for us to review and hear all of that. So that's an example, Your Honor, that is not us saying we just don't want to go to trial, we just want to drag our feet. That is us saying there are critical things that we don't have. I am very concerned about expert reports. We have a draft of one, the CAST report. The court had ordered that we receive the CAST report. It's a draft. I don't think the state has it. I don't think they're sitting back on it, but I don't have that yet. And there are completed materials all over the place like that we just don't have. Our team speaks with the prosecution team fairly regularly about these issues. We communicate by text and by email about things like this that are coming up. We've sat down and spoken with them. They're very open to talking to us, but this just isn't a closed deal. There has to be a deadline on discovery. There has to be a target date where that ends. And then there has to be time to make sure that we've read every piece of it, watched all the videos, looked at all of the photographs, and know where they came from.
Look at this
A few months from now
photograph.
is not a sufficient amount of time to do that. There is no possible way I can even read or watch everything I have now or react to things that are still coming in if we're to have a
I feel like she's
deadline in time for a summer of
Damn it.
2024 trial.
I'll wait.
There is no possible way that I would be effective in my investigation, in my presentation to a jury, if I don't have the state's expert materials ready to give to my experts and then give them a report to respond to. There is no way that I am effective assistance counsel if I haven't looked at every bit of discovery that's available.
51
Recently, Your Honor,
terabytes.
as recently as January 4th, we received discovery that contained over 9,000 tips that law enforcement had obtained. And we've had, this isn't a new issue, I think the court's heard about this before. We've had bits and pieces of tips and they've come in and we've reviewed them, but the 9,000 new ones we received January 4th, those were closed out in October of 2023. And I don't think the state sat on them. I think that's an example of the process that they close them out so they can give them to us, but they go through other agencies before they get in the prosecutor's hands to give to us. I have to read every one of those 9,000 tips. There are things that matter to us in our innocence phase that have come up and been done, and I have to read them and appreciate them and react to them and see what's there.
Hopefully you're a fast reader.
I owe to Bryan. That's his right for effective assistance of counsel to have me do those things. Your Honor, summer of 2024, it's impossible for us to do it. Our team constantly meets, we constantly work. We are on this. This is our priority. Bryan's our priority, but we are not going to be ready in June 2024. Your Honor, I want to also talk about some of the other deadlines. One of the things in the state's motion for scheduling order had to do with the alibi defense. And as a court remembers, we had made some submissions and we needed more information before we could do anything more complete. We're still in that circumstance. But when the court vacated its scheduling order last fall, that was part of the scheduling order that was vacated. So the state asserts in its scheduling order that our time has expired, and that just can't be because the court didn't carve that out and say, I'm going to vacate everything but this. So we'll need a new date, but I'd ask the court to be really mindful of the
I feel like she is
other information we need. We need the cast report. We need other information of things that past agents and other specialists with the FBI might have done with cell towers and records. And I don't have all of those yet. I have some.
13
and the
months.
state has pointed me to places that they believe I have more that maybe I missed in the discovery, and I'll look at those. But I'm going to need some time to do that. I wanted to let the court know as well, because the court's going to be considering a scheduling deadline for 12B motions. I want us to have a clear picture before.
I mean, I get her reason for wanting a delay, but
we have that
damn.
Deadline. And the clear picture that I'm concerned about is the state's pathway of how Bryan Kohberger comes to their attention and is identified. I've read that PC affidavit over and over and over again, and I'm not sure.
I just feel like she's trying to explain why she didn't get her final paper done on time. And she's just explaining like, my dad, my parents were
over a year
fighting.
into this case and everything I've read, and I've spoken with our team, we're not sure how the state decides on Bryan Kohberger. I know different pieces, but I don't know where they fit together. And the more work I do, the less I know about how they fit together. And that is critical for us to assess 12B motions. So while the court's doing deadlines for discovery, I
am coming up with as many excuses as I can so I could get this going on in 2025, the summer of 2025.
need the court to have something with the 12B keyed on when I have full discovery. I also think it would be appropriate for the court to allow windows to file additional motions based on later disclosed materials too. I think we'll just keep getting materials until the court sets a deadline for it to be cut off. Not anybody's fault, just the magnitude of the case. And so I think that would be something appropriate for the court to set as well. I think that covers it.
Thank you.
Is that it?
Question. So
Sure.
I understand this. I mean, I'm aware
Oh boy.
amount of disclosures already. But do we need a whole
He's like, do we really need a whole year?
another year
Yeah.
this summer? I
Thank you
mean,
for asking that.
Can I help everybody by having tighter deadlines to make things happen faster so that we can get this trial sooner?
Yes. Great question.
That's a tough question.
Good God.
If
Come on. That's a tough question.
if the state
Stop.
says you have everything and I believe they could say I have everything they have, but I know there's other things out there. I know it based on responses to discovery. If I had absolutely everything, all their experts
I'm sorry, but no,
with
dog.
courts, I would still need a period of time to read and understand that. There's not a shortcut for the amount of time that it takes to go through everything. There's just not a shortcut for that. Having a deadline for discovery helps me. It just does. Having a deadline for expert disclosures, that absolutely helps me as well. I have the concerns of discovery that's not yet made available. I have the concerns of the time it takes to review all of the materials.
I'm
And I
done.
have the concerns about the limitations we're
It is a little bit of call the ambulance.
finding with people being willing to talk to us, both for the innocence phase and the mitigation phase, should we ever get there. I have significant concerns. We're working on it. If you could say, everything's going to go according to plan, I'm going to give you these deadlines, and all of the materials will be in the state's hands so they can give them to you, and the records you need will be given to you when you ask, and the witnesses that you need to speak with won't slam the door in your face. If you could tell me that, then I would say I could be ready by March of
I'm assuming 2025. What's she about to say? March of come on.
2025.
There we go.
And that's me saying I'm going to spend every possible hour on Mr. Kohberger's case, which I've been doing and which I'm willing to continue to do, and so is the rest of his team.
Spring of 2025.
But my problem is that's best case scenario if we don't run into problems and delays getting records or getting people to talk to us. And if the next calls I make on the experts that I don't have yet secured, if they say yes and they're ready to go and have time to take it on, that's best case scenario. I'm nervous telling you I'll be ready by summer of 2025. I'm nervous telling you that.
What, you need 5 years, girl? Damn.
This is priority for everybody, and I want to be realistic about it. I don't want to set it more than once. I only want to have one trial, one time, so it doesn't come back. We can only predict the future so much. I only have so much power, so I'm relying on counsel deeply. So let's go to Mr. Thompson and see what you have to say about all this. Just getting things ready for trial.
Well, sir, it's a bunch of
Ms.
horse
Taylor
manure.
is not understating the amount of work that's involved in this case, Judge. I think that's fair to say, and there's more information that continues to be developed. It's kind of like you ask one question, you get an answer, and that leads you to another question. I know that Ms. Taylor and her co-counsel and investigators are encountering that. We are trying to provide things as quickly as we can, and she's right. There are delays in with the multiple agencies getting everything together. The tips, for example, were part of a nationwide.
Yeah. How about no? Yeah. I couldn't agree more. I think that she's just grasping at straws, so she has more time. But I get it. There's a lot of things. We're going to talk about it after this.
That needed to be completely shut down before we could get all the tips that were in it. And so that's why it took so long with these 9,000. I didn't count them, but there are thousands and thousands of tips, most of which are out there. But you're right. Most of all of which need to be looked at to see if they have any potential relevance to the case. As I indicated to the court, if we cannot have a trial this summer, then I would say the earliest would be the summer of next year, for the reasons that I've described to the court about the practicalities of carrying on a trial of that duration with the high school, with the universities. We need to be realistic about being sure that we can get our witnesses here. We'll have something to put them. That there won't be undue interruptions in the community that can cause issues with the community's perception of the trial proceedings. I'm not quite sure what else I can offer.
You're making some kind of argument that changing venue, but I know we're not arguing about that.
And I don't think that's going to change anything, Judge.
Facts.
When this case has national, if not international, attention.
International.
This spring, I was at Association of Council of Counties board meeting in McCall, and there was more news every morning from Boise on this case than we see up here. Every doggone morning. I have people, friends in this community who have traveled to.
I can't escape it, sir. Everywhere I go, it's about Idaho 4. Everywhere I turn, it is the. I don't know why he's Irish suddenly.
Mexico. And they say, people here were from Moscow. And immediately they want to talk about this case. It's not Moscow. It's not Latah County. It's everywhere. So
I can't escape it. Everywhere I turn.
well, I don't think that a change of venue is going to solve any of these problems. And the state's position on venue is that the case should be held here. It's a Latah County case. We believe that we can select an appropriate panel of jurors from Latah County. We have the tools to work with that we've discussed with Your Honor. In fact, we already have a fairly comprehensive draft juror questionnaire to send out so that the court and counsel can assess the level of knowledge and the feelings of the potential jury pool. But we think that we at least owe Latah County, the people of Latah County, the attempt to seat a jury here first, and not just rely on. There's been a lot of publicity. There's been a lot of publicity everywhere. The only place I've heard that there wasn't publicity
is where. That's why I'd like to know where. Where is it? But he's like, I'm sick and tired of this ish, man. Everywhere I
Lewis
turn.
County, somebody was talking to a court down there, and they happened to mention co-rotation. Said, "What are you talking about?" So if we want to change venue, I guess we could go to Nez Perce.
Kind of small.
It's kind of small. Lodgings aren't very good as far as a lot.
Sorry, guys. But yeah, I get it. But you also got to remember, prosecution's probably thirsty to take him down. They're like, we got enough stuff. Let's take him down. I don't want to wait another year. Let's just take him down. We got enough stuff. We got smoking gun evidence. It's a wrap. We got the bad guy. Let's bury this mother lover, right? That's what's going on here. That's what they want.
A lot of lodging. But I think that is a practical.
And let it do its thing. It needs to think for a second, guys. But what say you guys so far? I mean, what are you on the side of? Are you sitting here saying, hey, we got to be fair? You know?
Observation on this case.
Or no?
It's not just here. It's not just Moscow. It's not just Latah County.
It's everywhere.
Yeah. Thank you, Mr. Thompson. So you're saying, you're looking at this realistically and the amount of information, evidence,
I wonder what this question, who this question is for. Yeah, this is not great, but he hasn't made a decision yet. And watch him say, I need time to think about this before I make the decision. If he decides right now, I'll be surprised. But he might go, I need to sit and smoke my pipe and contemplate about this. You know what I mean? Which is still a strong possibility.
evidence that might be looking at summer of 2025.
I'm saying that could be where we end up, Judge. I am still concerned about the victims and their families. I mean, they have suffered for well over a year now with a lot of uncertainty.
Yes.
And that's painful. It's an everyday reminder. And they need some certainty and they need some closure in a timely fashion. But we know we also have to make sure, as Your Honor just said a few minutes ago, that we only do this case once. That it doesn't come back on appeal, that doesn't come back for subsequent things saying that somebody made a mistake. We want to do it right. And the factors are in front of Your Honor. I think that you're certainly in a good position to make the best decision.
He's like, I'm ready to take this motherfucker down.
It's a decision that pulls me in two different.
I appreciate that, Judge.
Yeah.
Oh, come on. Oh, come on. I'm going to let it do its thing. Oh.
I'm upset right now. I mean, I'd like to get a little closer with discovery and see if we can have that more quickly. I'd like to speed it up if it's possible. I'd really like to do this sooner than later. I mean, maybe March
Of 2025.
2025,
Fudge.
which Taylor, that would be a reach. I just want to let it percolate a little bit. I know everybody probably here, including council, want to direct a certain date. But when you're talking about a date so long in the future, potentially, maybe we can get to a point where we can move it more quickly. I'm not going to just let it hang for too long, but it's really hard for me right now to set something in 2025, even though that might be just the reality.
That can't be reality. Please don't let it be reality.
And I know that.
Please don't let that be reality. Like, for the love of God.
There's lots of other issues to be addressed. I know there are going to be a lot of motions. Going to be a lot of motions about the death penalty as well. So it's realizing to think that we have to have a case so far in the future. But if that's what is the right thing,
is it the right thing
to do it correctly? Maybe we only have to do it one time, because we don't want to do this twice. We don't want to do this 3 times, because no matter what happens, okay, if he's convicted, it's going to be appeal, and that's also a challenge. So my heart goes out to the victims. I can't even imagine the pain, the grief, because you can't really go forward with your life without this hanging over your head. So, sorry. We'll see. All right, so I'm going to contemplate a little bit. It's not like I have to set this within 2 or 3 months, apparently. And I want to do the right thing. So, does that conclude what we need to talk about today, Mr. Thompson?
I believe so, Judge.
Okay. Ms. Taylor?
Yes, Your Honor.
Okay, well, thank you all. We are adjourned.
Wow. Okay. There's a bit
live from the Stream Center. Breaking news on WFLA now. Here's
WFLA now. Breaking news. Okay.
The Kohberger murder trial will not be dismissed based on today's hearings, but it also might not be happening anytime soon. Judge hearing arguments on a trial start date with potentially March 2025, May 2025 on the table, and an unexpected twist. Arguments heard on maybe the concept of a venue change out of Moscow, Idaho, out of Latah County. Not expected today in the slightest. Welcome back into the Stream Center. So much to break down. I have so much notes. I don't know if I'm going to be able to get to it all on this live stream. Court is adjourned, allows us now the opportunity to break down what we have learned. Also an opportunity for us to answer as many questions interactively out of the comments section. You can use #AJB to get my attention across social media platforms, Facebook, YouTube Live, Twitter/X. You can use that as well. You heard Ann Taylor for the defense making quite an argument for, and really not even just making the argument, but listing all the reasons as to why doing a trial this summer is just, in her words, impossible. And I was jotting down a lot of notes. There were others tweeting this as well. I know my friend Brian Enton was also tweeting this out quite a bit, so I'm going to read this. But all of the monumental amount of evidence in this case, 51 terabytes of data, 10% only of witnesses being interviewed so far from the defense. You could hear.
All right, yeah, and he's got a point here. Hold on.
Trying to put together an appropriate legal defense, but I'll tell you, over the course of this entire argument that I am hearing, and over the course of John Judge's comments afterwards, as he is now expected to mull this decision as to whether or not he's going to allow this to be extended into 2025, I couldn't help but think about Murdaugh. Here we are with the Alex Murdaugh trial, the immense amount of resources, the exhausting amount of work that went into that case, and the potential of it happening all over again as a result of just a mistake. You can clearly hear, really from multiple parties involved in this hearing, that they want to do this one. You heard Judge say one time, want to do this one time. And we ran a poll on YouTube Live asking our audience as to whether or not they want to see this trial happen in summer 2024 or a later date such as summer 2025. More than 90% of respondents, of course, as you would expect, want this to happen sooner rather than later. Perhaps no one more than the families of Kaylee, Maddie, Ethan, and Xana. However, the last thing that anybody wants is a trial that happens prematurely and a trial that has to happen a second time, or a trial that's going to have so many holes prodded in it that an appeal is inevitable, or multiple or a litany of appeals are inevitable. So it's about getting it right. And with 51 terabytes of data, as somebody who is a bit of a tech nerd, 51 terabytes of data is massive.
It's massive.
We've talked about it on stream in the past. It's hard for people that aren't technologically savvy to really fathom 51 terabytes of data. Now, how much of that data is really going to be pertinent to the case?
That's another question.
To the point where it would be presented in a court of law, and how much of it would just be tossed out for being inconsequential? That we really don't know.
So let me just say this, because we definitely need to talk about this, and I might hop back and forth to his live feed just to kind of hear what he has to say about all that's going on. But let's talk about this 51 terabytes. Okay, let's talk about that, because for me it felt like homegirl came out and was sitting there going, "Oh, you know, my dog ate my paper and my parents are fighting right now, and I couldn't get to my computer because my snotty-nosed brother was too busy playing games the entire time." And you know what I mean? Like, she was using every excuse under the sun to push this court date. Now, let's talk about that. The 51 terabytes. They've been having it for a while. They've had the 51 terabytes for a while. You're telling me you haven't put even a small dent in the data? And you got to remember too, 51 terabytes does not mean, like he just said, does not automatically mean that you're going to be using every single last 51 terabytes in the trial. Some of it is tossaways. Some of them you just throw them away. Some of them don't matter, right? But you still have that information. You're sifting through photos, you're sifting through things. Some of it is not going to make it in the courtroom. It's not going to make it in their argument when they present it to a jury and to the judge, right? So for me, that doesn't matter. You could sit here all day long saying, "Oh yeah, you know, it was, you know, because of this, and this, we can't do anything." You got a whole team. And I get it. It's a lot of data. But hey, sounds like y'all need to start drinking Red Bulls, start drinking that coffee, and start diving into things. And here's the other thing. I get it, that there's witnesses and stuff like that while you're going door to door trying to get witnesses to speak so that they can speak on behalf, maybe on behalf of Bryan Kohberger, or just so that you can have a witness in the trial. And you're getting people slamming the door in your face. I mean, them are the breaks. Break it up, break it up, break it up. That's just life. You are defending a person that's looked at as a monster right now in the court of public opinion. So that's part of your job. I'm sorry. That's your job. So the fact that she's sitting there going, oh, it's because of this and because of this, and I can't do that, and I can't do this, and this happens, and that happens, that's pretty crappy. But still, you just need to start doing the work. The other thing, though, too, I will say this, though, too, okay, on the other side of things, on the other shoe, all right, on their side, okay, in defense of the defense, all right, I get it. That prosecution, the state is withholding a lot of information. They've been asking for a lot of stuff. They've been putting in filing motions for things to come to them, to unseal or to release documents, etc., to the defense. Apparently, the state has been dragging their feet about giving them information, giving them the data and the evidence that they have that's the smoking gun whatevers that's keeping this man locked up behind bars. I get that part. Now, you heard it from Judge. He's like, well, maybe there's something I can do to expedite things a little bit faster. Is there anything I can do to make that happen so that you guys can get what you want so we can have an earlier trial date? And still, it's not enough because we have too much that's piling up on our desks right now. We're overwhelmed. Okay, that's fine. Fine. But I agree, S-Dubs. I agree. I couldn't agree more. State needs to hand it over and just call it a day. And if it is something that's going to exonerate or release Bryan Kohberger, then let it be. If you guys did something illegal, you guys did something illegal. Quit hiding, quit faking the funk. Because I'm sure you can get him on something else. But we know for a fact, I mean, at least for me, in my personal opinion, I really do think that we got the guy. They got their guy. And that's why you could hear, even with the prosecution, I don't know what the lawyer's name is, but he came up and he's like, oh man, everywhere I turn, it's Idaho 4. Everywhere I turn, it's Bryan Kohberger. I can't escape it. It's impossible for us to be, to find another venue that's going to not be affected by this. This is an international trial. This is an international case. There are people who are flying all over the world coming into Moscow, Idaho, just to see where the house used to stand, for crying out loud. There is no place on this planet. He said one spot. He's like, there's one spot. It's like, so you're gonna go try them in some little, I didn't hear what he said, but what, you're gonna try them in some little town somewhere else? No matter what, people are gonna know. And if they know that a big trial like this is going into a place where it's never been touched, they all gonna get touched with it, because they're gonna be like, wait, who's this Bryan Kohberger individual? What's this Idaho 4? And the next thing you know, you got media, you got true crime fans, etc., going over there going, this will be the place where the whole trial will go down for Bryan Kohberger. Will he be getting the death penalty or not? We will find out. Everybody and their mama is going to be down there. So that town is going to get super saturated with more information. So damned if you do, damned if you don't, in my personal opinion. So they shouldn't even try to move venue, because it's going to be a wrap. As soon as everybody finds out, oh, they're doing it in this little corner of the world, Erie, Indiana, everybody going to be talking about Erie, Indiana. Everybody. And then Erie, Indiana is going to know. So that ain't going to work. You might as well keep it exactly where it is, in my personal opinion. It's very rare that people don't know about this case. I'm telling you right now, I'm not kidding. I was in the gym just literally yesterday. In the locker room, I'm changing, getting ready to get out of the gym. I just got done and all that. Ran into one of the guys that I see at the gym all the time. So we're chopping it up, shooting the proverbial ish. And there's another guy in the locker room, like across the way. And randomly, I'm like, yeah, that Idaho 4 thing is going down. And they both, like, because I'm talking to my friend, and I'm just like, yeah, tomorrow I'm gonna be covering this Bryan Kohberger thing. This hearing is coming out. He hasn't had a hearing in a while, so we're gonna find out if the trial is being moved or getting pushed back, or when we're gonna actually have a trial. And this other random dude that I don't even know from a can of paint turns around and goes, "Oh, snap, you talking about the Idaho 4 thing? Man, everybody knows, man. Everybody knows. This is a guy for a fact doesn't know anything about true crime, and he knows about this story. He knows about this crime. He knows about Idaho 4. He's like, Idaho 4, right? You mean you're talking about the dude who allegedly ran into the place and, took the lives of these 4 kids? These 4 college kids?" I'm like, yeah, that's exactly what I'm covering. He's like, man, that dude did that. And he's grabbing his stuff and he's walking out. And I'm like, damn. Even my boy, who is like, doesn't true crime, knows about the story too. It's impossible. People know about this. Okay? Everybody know about this story, man. Everybody. So it's impossible for them to change venue, for them to have an unbiased situation. It's going to be very tough. Long story short, the jury selection is going to be impossible, and it's going to be long. That's why she said, it's going to be like 12 weeks. Do you realize how long that trial is going to be? That's a long-ass trial. Don't worry, we will watch it. We will be there, depending if, you never know. This show might get picked up on a network. You never know. By 2025, damn. I'll be an old, decrepit, crotchety old man by then. Okay? It feels like eons from now. 2025. We just walked into 2024. That's a whole other year and a half, baby. Like dag nab. So the defense did their job. That's what I think. And you can't deny that his team, the defense doesn't suck. Okay? They don't suck. But at the same time, how long are they going to ride on the fact that they got 51 terabytes? They've been saying that for a while. They've been saying that for a minute, y'all. 51 terabytes? And do you understand how many terabytes that is? Like, come on, we already know about that. We've been known about that. When you first used that as your card, your ace up your sleeve, blah, we need more time because we have 51 terabytes of information and data. We already knew that. You guys didn't put a dent in it already? So it's just been chilling on that little thumb drive or a little hard drive, and you've just been chilling, looking at that, just collecting dust, going, eventually we got to attack that. What about your little minions? What about your team? Shoot, I've watched Matlock. Don't you have a team that works for you? That's doing the investigation stuff? That's doing the road work and also doing the research for you as you conduct other things? I thought this is how the whole thing went down. I thought she had a big team. Yeah. How big is her team? I'm wondering too. It looked like a gang of people in there on Kohberger's side. He came in mob deep up in this biz naive. What are you talking about? You don't have a team that can take some of the stuff, take a chunk, you take a chunk, you take a chunk, I'll take a chunk. And we spread it out to the other minions that are supposed to run out and grab the coffee. While you're grabbing the coffee, read these 3,000 pages. All right? You got 3. You see what I'm saying? Slowly start chiseling away at it. That should have already been done. So I don't. That's why I'm like, not done, but at least a decent dent should have already been made out of that 51 terabyte hard drive. And again, a lot of it's going to be trash. A lot of it's going to be trash, y'all. Okay? How long was the OJ trial back in your day, Pascal? In my day, let me get my teeth real quick. I don't remember. Honestly, I don't remember how long that trial was. I don't remember how long the trial was. I just remember it just being televised like crazy. And then the verdict, everyone went nuts. Literally, good, bad, happy, sad. The whole world went nuts when he was acquitted. That was a Hail Mary in my personal opinion as well. Yes. Even at that time, I was like, but he did it. Everyone else is like, yeah, you know? But I'm like, yeah, but he did it. Yeah, but he did it. He did that. Sorry, but he did that. So that was 3 or 4 months, Amanda? Give or take? Oh, Nicoletta said OJ trial 9 months. Damn, that's a long time. That's a long. See, this is Lisa White just said it lasted 11 months. So it was televised for 11 months? I'm sorry, guys. I'm sorry. But OJ did that. OJ did that. All right. He did that. I know that there's crazy theories out here, but nah. Nah. There's some crazy theories out here, but there's too many things were pitted up against him. The only thing that got him free was the glove. And that's insane. But I do think he wasn't alone. I will say that too. I don't think he was alone. And then, of course, if you're an idiot, Exactly, Maza. You're an idiot when you were going to write a book saying, if I did it, this is how I would have done it. You're an idiot. You're an absolute idiot. Okay? Way too much cocaine in your body. Altered how you think about the world. You're an idiot. The world is dumber for listening to you even say what you said. You collect no points and have mercy on your soul. That's what I think. All right. But yes, change of venue doesn't matter in my personal opinion. And I see that with the prosecution. They're like, it doesn't matter. It doesn't matter. Because no matter where you go, it's impossible. But I did find something I found it to be offensive to the state. Okay? I found it to be an insult to the state when they were like, you're just trying to quickly take this man's life. The state just wants to take this man's life. No, they want to serve justice. They have enough against him. They believe they have enough against him to take his ass down. You guys are delaying and dragging your feet in hopes that there's some Hail Mary moment that is presented to you. It's not the 51 terabytes, guys. You can't, sure, they got to still comb through all that, but they've been doing their work for a while. They have. They're hoping for a miracle. And they think that by holding out a little bit longer, they think that as the dust continues to settle, more and more people who have been hiding because this is such a high profile case, they're thinking that as it settles, it'll give those people who are scared because of the amount of attraction and focus this case has, they'll finally step forward. They'll step out of the shadows suddenly and go, yep, I was there. Yep, I was right across the street when I saw all this stuff, and it was a woman that walked in that house. Yep, yes, sir, Bob. A woman, not a man. Watch. That's what they're waiting for. They're waiting for a Hail Mary. It's not 51 terabytes. Come on. Miss me with that nonsense of 51 terabytes. They're hoping for a miracle. Will they get it? Will they get it within this year and a half or however long they end up doing it? That's a very, very good question. Very good question. But let me check something here. I was hoping to get some friends on, but I guess they're busy or they're not seeing it. But again, it's just, yeah, I ain't feeling it. Rob Slack, thank you so much for being a member for the past year. Oh my gosh. Thank you so much. Thank you. Hello, Pascal. It's me. Is it me or does Judge streaming it from his own channel seem like a conflict of interest, especially if he's making money from it? I don't know if he's making money from it. I don't think he's making any money from it. I'm sure I'm assuming it's demonetized, but I don't know, or I don't think it's monetized. But if he made money off of it, then I'm sure that money's going to go, I don't know, to the court or something like that. I'm sure there's some sort of deal they set up so that, it doesn't come off like there's some sort of bias, right? The Karen, thank you so much for being a member for the past month, and I appreciate the smiley face. Thank you so much. Thank you so very much for all the support. But again, yeah, guys, I mean, the math is not mathing for me either. When it comes to all this, 2025, okay, is a possibility. He didn't say, oh, it's definitely going to be 2025. He just said, I am going to think about it. I'm going to mull over the possibility of this going in the spring or summer of 2025. There's still on the table summer of 2024, like literally a couple months from now. And I have to say, just playing it on the other side of the fence for a second here. Would this be considered fair if the judge said, hey, let's push it to summer of 2025? Would that be considered fair? I know prosecution's sitting there chomping at the bit. They want to take this man down. But at the same time, he ain't going nowhere. He ain't escaping anytime soon. He's locked up. They got him. It's a wrap. All he has to do is survive. He just has to live till summer of 2025. That's all he needs to do. He needs to see the inside of a courtroom whenever the trial is supposed to go on. That's all they need. That's all they care about. But at the same time, I get it. They want to take him down. But if the defense is sitting here saying, hey, we don't have enough yet, we are still doing everything we can to get as much information as we can. We're trying to get witnesses. We're trying to get experts. We're trying to do everything we can to do with this. Is it fair for the judge to be lenient to the defense or not? Because if you really think about it, if the shoe was on the other foot, and if this was prosecution saying, we need more time, we are not ready, we need more time, there's 51 terabytes of information we need to get through, blah, 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 would we still be singing the same tune? Would we be like, come on, let's just get it over with? Or would we sit there and go, no. Wait. He's a bad guy, at least in the court of public opinion. If you need some more time to take this mother lover down and make sure it sticks, go ahead, baby. Wouldn't we? Wouldn't we? But he did try to get his indictment dismissed. That did not work. That was one of the first things that they presented and talked about in the hearing. And that judge said, no. How about no? Did I make a good point, Hannah? Oh, snap. Hey. Thank you. Stop. But still, Interesting there, right? She was on the other foot. They needed more time. Would we be okay with it? I think we would be, because we'd want to make sure that it sticks. Same thing with defense. They need more time, right? I don't like hearing that, but if that's what they need, that's what they need. I obviously have my opinion where I feel like they're looking for a miracle. They're looking for that smoking gun piece of evidence that could possibly throw reasonable doubt, like throw a huge log into the machinery of reasonable doubt. Okay. But I guess they haven't found it yet. Nicole, that's a good question too. How much time is too much? I'm wondering. I really am wondering. Hannah, overall, I just feel for the families. I feel for the families too, because they got to relive this every single day. But at the same time, hey, if you want to get it done right and you want to get it done right once, then they got to make sure that they got everything stacked up, both sides, so that they can just have at it. Okay. Get into that trial like they're Mad Max in the Thunderdome, okay? And it's one battle and one battle only. And once it's over, there's only one survivor, right? The winner, the champion, walks out alive. So we'll see. We'll see. And one thing I do want to remind you, from what the defense is saying, they're asking for the state to give up give up some things, and the state has not done that yet. They're delaying things and they're dragging their feet. That's not a good look. That's not good. And when they finally relinquish the things and give the defense the things that they want, could that exonerate Bryan Kohberger? I got questions, y'all. I definitely got questions. There is no it's so frustrating. Watch there be some big bombshell that happens within the next few months. And we're all going to just be shook. Like, what? Because you got to remember, there is a crap ton of information that we don't know, that the public doesn't know. The defense knows most. The prosecution knows a lot. And when that stuff does come out, oh my Lord, it's going to be so mind-blowing. All of us are going to be shook, like, whoa. So that was in the 51 terabytes? Wow. And you never know. A lot of it could be this mother lover did this. And that's all that's being seen in the 51 terabytes. Him following, lurking, saving photos, following them on social medias, all that stuff. All those digital footprints that he's left behind leading up to that tragic night could all be in that 51 terabytes. Then you also got to remember the surviving roommates. Hopefully they still are willing to step forward and speak out as well, to testify. I know they're trying not to, but maybe by the time 2025 comes around, they've been able to work out whatever they need to work out so that they can get on the stand and speak and hopefully just tell the truth. But BK's out here. BK is out here for sure. It's crazy, guys. It's absolutely crazy. Absolutely crazy. Mm-mm-mm. So, I mean, what say you guys? What are your thoughts on that information? Definitely let me know. Of course, I'm very much surprised and not surprised. Excuse me. Surprised and not surprised. I'm not surprised that we're doing this. You know what I mean? I'm not surprised that this could possibly be pushed all the way out to 2025. I'm not surprised about that. But we'll see. Anyway, guys, that is the show. I appreciate all y'all for being here. It really does mean a lot. I mean, you know, the hearing is the hearing. I was hoping to have some friends hop in, but they didn't respond. So understandably, I'm sure they're locked up, busy with a bunch of other things. But man, crazy stuff. Crazy stuff. Okay. And of course, when Judge finally makes a decision on when this is all going to go down, this trial, we'll talk about it, you know, but it's been a while since we've seen Bryan Kohberger out here. So, but hopefully the decision that the judge makes, I hope, is a logical one. And I hope it's a fair one. You got to remember, he also deserves a fair trial. I guess take that for what it is. Do me a favor, hit that like button down below before you head out. Also, I have a new pop-up video that I put up right before this show, so please go check that out when you get a second. That would really mean a lot. All right, it's about the Kansas City Chiefs. Fans, please go check it out. That'd be really appreciated. Hit that like button, hit that reaction button. Don't forget to hit that subscribe button if you're watching on YouTube. If you're watching on Facebook, crush that follow button on my Facebook page. Be greatly appreciated. Check out my merch page, pascalmerch.com. Join the Pascal Show family by hitting that join button down below. That'll be greatly appreciated. Okay? And I'll be talking to you guys very soon. All right? Pretty wild stuff. Kind of uneventful in a way. But we at least know that there's motion happening right now. So we'll find out soon enough when a date is set for this trial. All right. Anyway, guys, it's time to get going. Much love to you guys. I will see you guys very soon. Be good to yourselves. Be good to one another. And if I don't see you guys this weekend, have a safe and wonderful weekend. You guys deserve it. Do something positive with yourself. Do something nice. You feel me? Do something nice for yourself. You deserve it. All right. And I'll talk to you guys soon. This is the Pascal Show. Bye.